All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning.
We are on the record in CV 20-0642. This is Gallo v. Gallo. We're here for oral arguments. Counsel, please keep in mind that these proceedings are being video and audio recorded and live streamed. So we ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock and the podium there. To reserve a portion of that time for rebuttal if desired. Also, please keep in mind that we have read the briefs and conferenced the case this morning. And with that, counsel, you may proceed.
Thank you. Good morning, Your Honors. My name is Christina Hamilton. I represent Brittany Gallo, who I will refer to as Mother during these proceedings. We are here basically on two issues with regard to the adherence to utilization application of Rule 69. That's a legal decision, not a factual decision. The court erred legally in not following Rule 69 when she had already approved the Rule 69 parenting plan, and Engstrom v. McCarthy says once it's approved, it has to be put into the decree.
I'm sorry, please. Let me ask you about Engstrom.
Sure.
But before I do that, at what point in time did the court adopt or approve the Rule 69 agreement that addressed parenting time?
In February of 2019, there was a minute entry that stated that she was adopting the Rule 69 agreement. It says, as long as the visit went well, the parties would then revert to their Rule 69 agreement, which provided parenting time for father every other weekend and the Wednesday evenings. Then again, in February...
But revert to me sounds like reverting to something that's already been previously approved. When was the actual approval, as opposed to her just telling the parties to continue to comply by your own?
I believe that this hearing was the first hearing in front of Judge Bergen on any issues of parenting, and that's when she said father would have to go through this apology visit, and then he would revert to the parenting agreement that everyone at that time was agreeing was the applicable parenting plan.
But doesn't Rule 69 generally require a court to approve a specific agreement and make a finding that's in the best interest of the children?
I don't know that Rule 69 does, but I think you might be right that ARS 25317 does. But the court never had any question about whether it was in the best interest of the children, nor did anyone ever present any issues that it wasn't in the best interest of the children. And father was the one who was repeatedly asking for that schedule to be applied.
Well, isn't that a little inaccurate? Because mother was asking to deviate from it, which suggests that it was not in the best interest of the children at that point.
Mother was asking just that Sundays would not be overnights. That's true.
So how can mother take the position that that was all in the best interest of the children when she herself several times asked for something other than what was in that agreement?
So let me break that down a little bit. So during the court process before we got to the trial, mothers asked for conditions to be put on father's time because of various acts that had occurred. And even Engstrom versus McCarthy says the court has the right to put conditions or restrictions on a parenting plan, even under Rule 69.
She wasn't just asking for conditions; she was asking for changes. As you noticed, the Sunday evening was different than what the parenting plan had provided.
Right. And I was going to just address that. So at trial, that's when she asked that the court consider not having Sundays be overnights, but she was very firm that she wanted the Rule 69 schedule, but for asking for that change as a condition or restriction.
And it's fine that she said that, but you can't have it both ways. It's either the Rule 69 agreement or it's not under those circumstances. The Rule 69 was Sunday overnight.
Mm-hmm.
Mother didn't want that.
Mm-hmm.
And took the position that the Rule 69 overnight on Sunday wouldn't be in the children's best interest, I'm assuming, because otherwise why would she ask?
She did take that position, there's no question, and she did think that that was in the best interest of the children, but that was a request to the court, not anything asking the court to deviate from the Rule 69 agreement other than on that particular overnight.
And mine's a slightly different question than what Judge Goss is asking, but okay, assuming that she thought that the Rule 69 agreement was in the children's best interest, Doesn't her request for something other than that indicate that she thought that it had not been accepted and was not enforceable at that time?
Mother walked into the trial saying, I want the Rule 69 agreement. I'm
No,
asking.
you already said that. She said,
Okay.
I want the Rule 69 agreement, but for this.
Mhm.
So that means that it's not a complete agreement that she thought was enforceable.
She thought it was enforceable. She was asking the court to deviate on the Sunday nights, but she did think it was enforceable.
What
How did
authority-
how did she ask for something different if she thought that the agreement was done?
Because she was asking the court to change just that one little part of it. So she thought that, the parents had
Do you have any
agreed.
authority for an agreement can be enforceable in less than toto?
I don't have any with me today, but on the same token, again, I point to Engstrom versus McCarthy, which said the court has the right to put conditions or restrictions on a Rule 69 agreement in the best interest of the children.
Counsel,
Yes.
sorry, you've been
That's-
asked a lot of questions,
that's okay.
and I want to let you on with the argument that you've prepared. But as to Engstrom, isn't Engstrom procedurally just a little different? And what I mean is there, the Superior Court has at a resolution management conference made an express finding on the record that the agreement was fair and equitable, in the best interest of the parties' minor children, and also that the court approved the agreement, quote, as an enforceable order of the court. The court made those express findings. And I understand your argument, but would you agree the court did not make those express findings here?
I
They
will
didn't
agree.
use that language.
I do agree.
Okay.
Yes, yes. In any event, we believe that under Rule 69 and Engstrom, the court needed to enforce the Rule 69 agreement. The court failed to follow Rule 69 in that it suggested that under Rule 67.1, under collaborative divorce, once collaborative ends, those agreements no longer become operative, but that's directly violative of 67.1H. So we believe that the court erred in not affirming the Rule 69 agreement terms in the decree. As to the debt to the parents, I should go back. Father never suggested there were any defects to the Rule 69 agreement, never suggested that there was any problem with it, nothing. His only thing was, I would prefer to have week on, week off. But he never said that there were defects under Rule 69. He had the burden of overcoming the presumption of the validity of the Rule 69 agreement, and he never even made those arguments. Similarly, he never made any arguments that the Rule 69 agreements were no longer operative because of lack of the collaborative divorce process or anything. The only thing that has been said is that Father believed that, in their brief, that since there were all these changes during the interim period, that invalidated the Rule 69 agreement. And again, the court was trying to put restrictions on because of various behaviors that were happening during the time to protect the children, but ultimately...
Come back. Mother invited the court to make a change. The court didn't adopt the exact change Mother wanted, but the court made the change at Mother's invitation.
During the
Is that a fair
interim...
assessment?
During the
You
interim...
just didn't get the one you wanted.
During
The
the
client
in-
wanted.
I just need to understand, during the interim process or during the trial?
During the trial, Mother invited the court to make the change.
Correct.
The court did, in fact, make the change, just not the one that Mother was.
Well, that is true.
And I understand that.
Mhm.
But how is that error when Mother invited the court to make the change and just simply didn't follow her recommendation?
Because I believe that the court had the responsibility to look at the Rule 69 agreement, enforce it, and then determine whether or not there were any other changes that needed to be made to it to protect the children. That's what Engstrom says. As opposed to saying, okay, we're just throwing this out, and now we're going to a 50-50 time plan. The second issue that 67.1, she said that the debt situation with the parents was not a part of it because of 67.1. As I just said, that doesn't apply, but more to the point, Father signed the Rule 69 agreement, and it says, this is a community debt, those are the words that were used, and we will split it 50-50. So any issue of vagary really kind of is mind-boggling, because it said community debt, and all she had to do was plug that language from the Rule 69 agreement into the decree. Talking now about the income issues, we understand that that is a abuse of discretion standard, but at the same time, the court has said that you have to have, if it's devoid of competent evidence to support the decision, that's legal error. And in this case, father filed multiple AFIs, affidavits of financial information, that said he was spending at least $15,000 a month. And he didn't do it just once, he did it repetitively. And he acknowledged he was paying a $9,300 mortgage, and his bank statements were all analyzed by the expert, and the expert said he is spending $240,000 a year, independent of his affidavit of financial information who said he was spending $180,000 a year. And it's mathematically impossible to be able to spend that amount of money and only make $77,000.
Unless you're spending your assets.
He didn't have any assets. That was clear throughout the entire process. So there was no evidence of any savings or assets or anything that would have been available during the period of time the divorce was pending and at trial that would have supplemented his ability to make these payments. Again, father never claimed that he wasn't making these expense payments in his affidavit of financial information. The Sherman case says that that the guidelines anticipate that we are going to look at all the resources of the parties to determine what is just and fair for child support. And obviously, father has resources. He never disclosed, but he had resources where he himself was saying he was paying over $15,000 a month. There is a comment made in the opposing counsel brief that says he was, something about the mortgage, that the court didn't include the mortgage. It's true that in the $77,000 the court determined the income to be. In that box, there was no determination or utilization of the mortgage payments. She said that's not a business expense, but husband's still paying those $9,300 a month payments. So even under the court's determination of income, if you take the $77,000 plus the $110,000, which is $9,300 times 12, he's back at $180,000 by his own testimony. This has nothing to do with the expert, as they keep arguing. It had nothing to do with the VRBO. It had to do with husband's admissions of what he was spending. And that should be deemed income to him. Finally, on the cross appeal, there were comments in the pretrial statement. Here are the amounts for the medical insurance, and here are the amounts for the school costs. She was in preschool. The record is repetitive that father knew she was in preschool, was picking her up at the preschool, knew that there was a cost to it, knew that they had health insurance through mother's employment, and mother testified at the trial to the numbers that were put into the worksheet. Father's argument seems to be that because mother testified to that, that's not sufficient, that there had to be documentation, but they provided no case law to support that. And at the same time, the Kaufman case says that when the testimony is uncontradicted, the court has the right to rely on mother's testimony. It doesn't say mother's testimony, but had the right to rely on it. So we believe that the cross appeal has been without merit. And finally, we are asking for our attorney's fees and costs because we believe that father is the party with the greater financial resources and has taken unreasonable positions. And with that, I will reserve the rest of my time. Thank you.
Thank you, counsel. I show you have about 6.5 minutes.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Erica Levitt. I'm here on behalf of TJ Gallo, the appellee in this case. I want to start first with the Rule 69 agreement. It's an interesting position that they've taken that any change that she wants is just inviting the court to do something a little different. But if father wants a change, absolutely not. It's a violation of the Rule 69 agreement.
Counsel, let me ask you this. If the court had accepted the Rule 69 agreement, if the court did accept that Rule 69 agreement as to parenting time, wouldn't you agree then that the court erred in its ultimate parenting time order that contradicted that Rule 69 agreement?
Well,
If the court had accepted it.
if the court had accepted and it was a final order, just like an Engstrom, perhaps. However, we have a few different facts in this case. There were a lot of circumstances and changes within the order. So if mom believed that the Rule 69 agreement was enforceable, had been adopted by the court, she went to the court and asked that father's time be supervised. She asked that father's time be limited. She asked, I believe, 3 or 4 different times for supervised visitation, limited visitation, and no visitation at all. And so the court has the authority to make emergency changes if that is in the best interest of the children. So in this case, even if the court had adopted, which we don't think that it did, there were changes. The Rule 69 agreement, as it was, changed as early as January 2019 when they had agreed to it in November of 2018. In that case, by the time the court had gone to trial, mom was asking for a change in the Rule 69 agreement, a change in legal decision-making, and dad was doing the same. And the court was then tasked to determine what was in the child's best interest. And the court looked at the facts, looked at all of mother's behaviors, looked at father's behaviors, and determined that a 50-50 time was in the child's best interest, and even modified the Rule 69, if we're going to call it that, in favor of mother, giving her final say in legal decision-making. But mom's not appealing that. She's just saying, well, I don't like this portion of the Rule 69 agreement that was modified. I only want what I want. And so in this case, we believe that the trial court was within its discretion to order 50-50 time with the children.
So is it fair to say that even if the court had adopted it, your position is when both parties come in later and say, really, that's not the right thing anymore, that when both parties have abandoned the Rule 69 agreement, the court has jurisdiction to make a modification?
Absolutely, yes. All right.
What would be your position then as to when she abandoned it? Did she abandon it when she withdrew from the collaborative process, or when she actually sought affirmative modifications?
When she sought affirmative modifications to it in January of 2019. There is no supporting case law, and we will fall on the sword for this, for the court's decision to say, well, when you're in a collaborative decision, Rule 69 agreements are not enforceable anymore. There's no support for that, and we will readily admit that.
So then, as to the debt division, then the court was mistaken then when the court said, as to the community property loan that mother says existed, and the Superior Court reasoned that once the collaborative law process ended, the Rule 69 agreement addressing community property is no longer enforceable. That was a mistake. Is that
Correct.
what you're saying?
Yes, there's no way I can defend that decision because it's just not supported in law. However, the court also made the finding that I don't know if this debt that you put before me is actually a debt. Is it a debt? Is it community property? So we have very vague language in that Rule 69 agreement that says if there's some community debt, it'll get paid. It wasn't until trial that mother came and said, well, it's a $160,000 debt and it's owed to my parents and that's what father owes. She didn't have a promissory note. She didn't have anything to establish that that debt that they were talking about in the Rule 69 agreement was the debt that was before the court at that time. And so the court said, I can't affirm this debt. I can't say that you owe half of it because you're claiming that this debt here is actually a gift, not the community property. So the court's decision doesn't negate any real debt. The parents can go to civil court. They can try to enforce the debt. Husband can make his gift claim, and a civil court can decide whether or not this is an actual debt. And if it's an actual debt, then each party would be required to pay the 50% of it. But what the court did was say, you did not provide enough information for me to determine that this debt right here is the same debt that was agreed to in the Rule 69 agreement. And so you're going to have to figure it out, not right here, not today.
Is the Rule 69 agreement severable in that regard then? I mean, if she basically waived it or nullified it through seeking modifications to the parenting time, why would we enforce, or why should the court enforce other provisions? I assume that, generally these agreements are kind of a negotiated settlement of the entire case. So why would part of it stand if the other part of it doesn't?
And we would argue that it shouldn't. I agree with you. If it's Rule 69 agreements are typically globally, there was nothing in the document.
They were two separate Rule 69 agreements, right? There was one addressing one addressing the community debt involving mother's parents, and then it was a separate Rule 69 agreement addressing parenting time and legal decision making, correct?
Yes, and signed on 2 different days.
So let me ask, because what the parents agreed to, or husband and wife, was husband and wife is awarded 50-50 of the community outstanding debt owed to mother's parents, Maureen and Garrett. Each will separately owe 50% plus interest, if any. So there was an agreement that there was a debt. Is it an abuse of discretion, given that there was an agreement there is at least a debt, to not find any debt by the Superior Court? Because the parties agreed there was a debt.
I believe what the trial court did, and let me just verify my work here, but essentially said that it couldn't find that specific debt, the $160,000, was the community debt, because there was an argument whether or not it was a gift or whether that was the community debt that was established. And again,
Did the court find any debt owed to the parents?
no. And if I...
So are you conceding then, Judge Goss's question, that there, by finding no debt, that is inconsistent with the community, or with the Rule 69 agreement regarding debt?
No, because the Rule 69 agreement said the community debt, I believe that it says if any. And so...
Wait, the Rule 69 agreement, I'll come back, because I'll read exactly what it says. And just have to give me a moment, I have it open here. It says, it's paragraph 9, husband and wife is awarded 50/50, 50%/50% of the outstanding community debt owed to mother's parents, Maureen and Garrett. Each will separately owe 50% each, plus interest if any. So there is no reference to a bank loan or anything like that. It was just, there is a debt owed to the parents, and that they will each bear 50% responsibility. So that's the language.
So then it could be appropriate for the court to say, if you can prove this debt. However, the court found that she couldn't prove the debt. It was the ambiguous and vague portion of it is how much of this debt is there. She, at trial, when she made the Rule 69 agreement, there was no statement of how much this was. It wasn't until trial that she is saying, you owe $160,000. And husband says, whoa, that wasn't community debt, that was a gift.
Wait, I thought your argument just a second ago was that the if any at the end there applied to the entire debt. Are you now saying that there wasn't an agreement there was debt? It was saying if there was any debt.
Well, yeah, if there's a debt. So if they owe an outstanding debt, then they would each owe 50% of it. So the argument is... Is
that a strained reading, though? Because when I read that originally, I thought it was just talking about interest, if any. But you're saying that if any applies to the entire debt.
Yes. And again, if there is community debt and the debt is found to actually be a legitimate debt, then this provision, I believe, would be enforceable. They would each owe 50% of that. And that's what the law says, that they would each be required to pay 50% of that. It's standard community property law. Community property law. But the issue here is whether or not the $160,000 that mother is claiming is that debt, is that actually community debt, or was that a gift? The trial court said, you did not provide enough information for me to determine whether this was a gift or whether this is actually a debt. And the parents have the ability to go to the court to get this to determine whether or not this is an actual debt, get a judgment, and both parties would be entitled to 50% of it.
Basically, your position that paragraph 9 is simply a statement of the law, that there's community debt, and when there's community debt, each spouse is responsible for half of it.
Correct.
And so it's your position is it's nothing more than a restatement of the law, and that it's not any agreement that there is in fact a debt.
I'm sorry, can you say that again?
It's not an agreement that there is in fact a debt. The only agreement is that if there is one.
Correct.
But then how do I deal with that first sentence? Because the first sentence is a declarative sentence. It says husband and wife is awarded 50-50 of the outstanding community debt owed to mother's parents mortgage and grant. There's no condition on that sentence.
But what is the outstanding debt? That's what the question is. She's saying it's $160,000. He's saying, no, that was a gift. So there needs to be a determination. If there is still that outstanding debt, what is the amount of that? And the court said that that wasn't done.
And so really the second sentence isn't relevant to that analysis.
If there's interest.
If any argument falls flat to me. It's at the end of the sentence, and grammatically it would modify what precedes it, not anything else. So is it really that the court had discretion under this agreement to determine what the debt was and found that mother didn't prove the debt sufficiently to accept?
Yes.
Okay. Not a trick question.
Going towards the argument of the income, mother states that the court had no evidence whatsoever to do what it had done. However, the court had Airbnb projected earnings. That documentation provided kind of a printout as to when would be the most busy times, when would the less busy times, kind of a projection of what the earnings would be. It had cleaning fees. The VRBO exhibit showed that there was fluctuating prices for the rental of the house. And so the court looked at that, looked at also the profit and loss statements, and essentially, based on the information that it had, tried to come up with what it believed was a fair income for father. Obviously, father took the position that he made less than that. Mother took the position that he made more than that. The court took all of that information and determined her own income. As to their argument that father himself agreed that he spent about $15,000, I would just like to make the court aware, or bring the court's attention to the AFI. He stated, or there was testimony in the record stating that the house was in foreclosure. In addition, the expenses that I believe that what mother did was take some of these debts that on the AFI it states that he hadn't paid since May and June of 2019, also in 2019. So if you add up the expenses, take out the debts that he hadn't been paying plus the house, you're only at $5,230, not the $15,000 and some change that mother is claiming that father is spending. And that amount comes to about $64,000 a year, which is less than what the court attributed to him. In addition, there's testimony in the record that essentially states that father had $750,000 in savings. He depleted all of his assets, borrowed money when he could, did whatever.
Mother takes the position there's nothing in the record to support this spending of assets. Is there anything in the record to show he was in fact spending assets?
So we've got testimony, trial testimony, essentially where he had said that he spent, and I'll direct you to it here really quick, that he spent all of the money that he had, that he was living on credit.
So beyond his testimony, I think that's what we have. And I'm not suggesting testimony is not evidence. I think both parties would agree with that.
Right. So if you look at the trial transcript too, on page 137, that's where he talks about the savings that he had spent, and also what he had done as far as income and to pay for his living expenses. As far as the cross appeal goes, it's just our position that these expenses are easily provable by documentation, and Mother should have done that. Whiten and Nash talk about appropriate evidence.
Earlier, you talked about how it was inconsistent of Mother to make certain arguments. Aren't you doing the same thing here?
Perhaps. And unless you have any other questions,
Thank you, counsel.
thank you.
May I? Thank you. Just want to address a few things. To your questions about Father saying he had savings, Father testified that in 2014 he closed his business, was done, that there had been $750,000 in savings, and by 2016 they are borrowing $160,000 from the parents because they don't have any money. And this divorce ranged from 2018 to 2020. There was no evidence of any savings or any assets that could have been used to support the expenses.
Isn't this just a credibility determination, though, where Mother's saying one thing, Father's saying another? There's no promissory note. There's no other testimony. It's those two, and the court has to make a credibility determination as to the amount of the loan, if it was a loan or gift. Isn't that really just a credibility determination?
I don't believe so, and here's why. The Rule 69 agreement says husband and wife is awarded 50% of the outstanding community debt owed to Mother's parents, Maureen and Gareth, each will pay 50%. That's all she had to plug into the decree. She didn't have to decide
No,
it's
but
100.
there still has to be some proof as to the amount at that point, right?
I don't know
Because
if
the
it has to
agreement
be.
didn't say 160,000 in community debt. It said the community debt. And then someone still has to prove the amount of that debt.
But not in the
Correct.
divorce case, right?
Does someone still have to prove to the court what that Rule 69 agreement, the amount of debt that Rule 69 agreement provides?
I don't believe so, and here's why. Because, may I?
No.
I'm sorry.
The court has to make some determination, right? As to how much
As to
that
the
debt is.
division of liability, yes.
Okay. Who has the burden to prove the amount of that debt?
The parents, when they go to collect that debt against husband and wife. So all the court had to do is just say, there's a debt out there, you're responsible 50% mom, you're responsible 50% dad, and when the parents then come to collect, and if they have to sue these people, that's when they'd have to show up showing the amount that was due to them. All the court is doing is
How did
saying,
the court's ruling here then change that?
well, it didn't really change that, but it didn't assess liability to either parent. It didn't assess anything. So
Under your position, how can the court equitably divide assets? Because you're saying we could, as a court, just ignore how much is owed and just say parents will pay 50% of this, parents will pay 50% of that. But normally, there's a more precise division of the debt and the assets.
If you had something that was concise and precise, certainly. But, for example, a lot of times in a divorce case, there's IRS liabilities that are unknown because they're being litigated or determined, but the court still says, okay, whenever that's determined, mom, you're paying 50%, dad, you're paying 50%.
Does this decree preclude the parents from bringing that civil lawsuit against both of them?
No, it does
So
not.
they can still do that?
They can still do that.
All right.
I just want to go back to, so opposing counsel takes the position that all of the Airbnb and VRBO projections gave us an income of somewhere around $64,000. But that doesn't explain how he can spend $180,000 to $240,000 annually on expenses. The court made assumptions when it determined the $77,000 for which there was no evidence. It determined when there were busy months. It determined what expenses should be included that there was no evidence of. It said she should get a 10% accommodation for having to go someplace else to live while the people are in his VRBO. There was no evidence of any of those things. Opposing counsel talks about the house being in foreclosure. The evidence was, and the husband testified in his deposition and never discounted this at court, that while it was, quote, in foreclosure, he had done a workout, and the workout was he pays $9,300 a month, and they don't foreclose. And that's what he had been paying, and that's what his AFIs reported. The argument that opposing counsel made just recently that said, oh, if you go into his AFI and you look at all of his expenses and you take out the payment of debt that he listed, but he hasn't really been paying, you're only down to $64,000. That argument was never made at court. It's never made in their appellate argument. And, you know, it is not consistent with husband's own testimony that he was making these expense payments. You can't get around $9,300 a month, which is $110,000 annually, and suggest that he's only making $64,000 a year. The math just doesn't work. Hang on just a minute, please. The argument on the parenting, again, I think that we're all kind of getting a feel of the fact that husband never came to the court and said there are defects to the Rule 69 agreement. Yes, wife came into the court and said, I want the Rule 69 agreement. Would you consider taking the Sunday overnights out? That should have been the issues in front of the court, but instead the court basically didn't even discuss the Rule 69 agreement as it relates to parenting, and then just went off as though it really were never even in place, and then decided that there should be a 50-50 parenting plan. There were two separate Rule 69 agreements, Your Honor.
I have a final question while you're looking at that.
Sure.
Which is, if the parents were to bring the action that I had suggested, and the court found there was in fact a debt owed, then they could come back and seek a modification under undivided debt. Fair assessment?
Yeah, I agree. The other thing I just wanted to add is that there was a suggestion that during the process, and there were these various restrictions that were put on husband, that was wife asking for affirmative relief. There were orders of protection in place, and that's what was happening. And when one order of protection was in place, the court accepted a Rule 69 agreement to vacate that as long as husband was on this very rigid schedule. So if you really want to talk about, is there a Rule 69 agreement, that was the Rule 69 agreement when the court asked the parents and made all the statements about this is in the best interest of the children.
So the court, when it wanted to accept a Rule 69 agreement, knew how to do it, and,
Yep.
and the record reflects that.
Yep.
And wasn't
Thank
that
you.
just a temporary order?
It was at a temporary order, yes. But the order of protection was a year long. Yeah. Thank you.
Thank you. Ms. Hamilton, Ms. Levitt, thank you for your both your briefing and your arguments here today. We'll take the matter under advisement and issue a written ruling in due course, and we are in recess.
Thank you.